Good afternoon and welcome to Construction Roundtable, Top 4 Legal Risks for Federal Construction Contractors. Thank you all for joining us today. We're very excited to be here with you. I am here with my colleague, Jessica Hoffman. I will let her introduce herself first.
Good afternoon, everyone. I am Jessica Hoffman. I have just launched the construction practice group, and I'm the chair of that group at Polera Mazza. And I'm happy to be here today to advise on some of the bigger issues in construction currently. And I've been doing construction for about a little over 20 years, so I'm excited to be here today.
Great, thanks, Jessica. And of course, my name is Nicole Atala. I'm a partner in the Labor and Employment Practice Group at Polera Mazza, and obviously prevailing wage work and construction work collide frequently on federal construction projects. A number of our clients are work in the area of construction, so we're very excited when Jessica joined our team. It's a very nice complement to the work we've been doing with clients for well over 30 years now. Polera Mazza is a business law firm. We like to be strategic partners to our clients, whether you're in federal contracting or a commercial construction contractor, thinking about getting into the federal sphere, or just want to know more about this area. Our goal is to really work with clients to be solutions oriented and to think about the issues they might run into before they run into them. And so when Jessica and I were talking about what content to bring to you, what is on our wish list for things that clients, if they could just see it when it's coming down the pike, or just be a little bit more proactive, what we could help them with, we really thought this roundtable type of discussion forum would be beneficial to our clients. And so after some discussion and talking about really what are the big ticket items, if we could look at things from 10,000 feet, 20,000 feet, that we know on a day-to-day basis cause our clients so much time, energy, and money, we came down to project management resources, prevailing wage liability, bond claim challenges, and subcontractor and supplier liability. So we're going to spend the next hour with you, a little short of an hour with you, kind of diving a little bit more into the issues that we see. You will notice we're not going to get into, really deep into statutory construction. We want to have a discussion with you all. So if you have questions, please feel free to pop them in the question panel. If we don't get to them today, because an hour goes fast when you're talking to lawyers, we will definitely follow up with you. But we're hoping to get to some questions as we move throughout the webinar today, and we appreciate that you've all taken an hour out of your day to spend with us. So with that, I am going to turn it over to Jessica to kick off project management resources.
Thanks, Nicole. So one of the, when I had an opportunity to really think about what the challenges are to clients and what some of the issues I see when a client comes to me with a problem on a construction project, the issue of project management resources comes to mind. A lot of times on a project, and keep in mind, I represent significant subcontractor trades, significant suppliers, as well as general contractors, and I, from time to time, will represent commercial owners. So I see issues from all different sides of the parties. And one of the issues when a client comes to me with changes to work, whether that is something has happened on the project where there's been additional work, extra work, or different site conditions, and we'll get into all of these issues. A lot of times the client is coming to me kind of at the end of the project, indicating there are all these open items, dealing with change order requests, changes in the work, impacts to the work. And one of the things that I'll ask is, okay, well, let's start gathering the information to get a claim together or a notice together. And it's amazing to me, a lot of clients are very well prepared in this regard and have the systems in place, and they track costs and provide notices and have all the documentation. And then there are clients that really are scrambling to piece together a kind of a half a puzzle from which we could cobble together a claim. And some of the things I want those that are in the industry, regardless whether you're a subcontractor or a general contractor or even an owner, is keeping a track of changes to the work and managing the changes to the scope of work and how they're going to impact claims and recovery. So one of the first thing is scheduling. If you're a contractor or subcontractor on a project, on a federal project, there's going to be a baseline schedule, there's going to be CPM updates, there should be for every claim attendant with a schedule. Many of the federal contracts will require a time impact analysis. So it is good practice, and it is normally required from the contractor to do CPM updates with narratives on a monthly basis. I also will routinely recommend that my significant subcontractor trades do the same: electrical, HVAC, plumbing, trades that can get caught up in scheduling constraints. And the reason why I think that is important is because this is the opportunity in real time, or at least on a monthly basis, to provide your side of the story and how it's impacting the schedule. And by the time you get to a claim, if I take that to a claims consultant, that information along with the P6 schedules is largely packaged together, done, and it makes the job for the claims consultant that much easier. It also gets rid of and eliminates issues by the owner or the contractor, depending on who you are in the line of trades, of notice. Hey, I wasn't aware that you had all these time impacts. These monthly updates or notices really helps in that regard. Impacts to costs as well. This is one of those issues where if there's a change to a project, some clients do a good job at really cost coding and segregating the costs associated with changes and impacts, and others are not. It is really good practice to, when a change or change order request or anything that differs on a site comes along, regardless of a dispute. Maybe there's a dispute whether it's a differing site condition or a change to the work, but immediately you should think, okay, well, how can we segregate the costs associated with what we believe is a change? And whether that's cost coding, alerting your subcontractors, laborers, folks that are doing daily reports, a way to cost code and track the expenses that are going into that change. And that is really important. Otherwise, you're going to pay, and this happens all too often. In fact, I'd say over 60%, probably 70% of the claims I deal with where I work with a claims consultant, the bulk of our time, particularly the claims consultant, is trying to document both the schedule and the impacts of the change to the schedule and the costs. And when we speak to the costs, that becomes really important, because when you submit a claim and you're asking for costs, you automatically need to start thinking about the False Claims Act to make sure, one, is it recoverable? Two, is it associated with the changed work? So it really is important from the beginning to cost code and track the cost associated with changed work. The other issue is sub-tiers. When a change happens on to the work, one of the things that a contractor and significant subcontractor should immediately start thinking about is, have you advised your lower tier subs? What does your contract say with respect with those lower tier subs as to claims associated with changes? Have you asked those lower tier subs for their claims and impacts, put them on notice, and given them an opportunity to submit their own claims through a pass-through? Your failure to do that can have implications, and we'll talk about those later on, but one of which is, if you don't give your sub-tiers the opportunity to pass through a claim, you can end up being in a situation where a pay if paid clause doesn't apply because you got paid and didn't pass up their costs. You impeded or prevented their ability to obtain their cost impacts associated with changes to work. The other thing that, and I know I'm probably going way too fast, but I'm trying to be cognizant of the 1 hour we have. The other thing that you should start thinking about immediately when you know that a change has happened or you believe there's been a change, and this is something that should be part of training with your supervisors, your foremen, your project managers, is the notice requirements. And this really goes to contract administration. The second that you believe there's been a change to the work, someone needs to review your contracts or subcontractors and the relevant regulations to see what notice needs to go out to whom and when. A lot of times we can often get around some notice issues, but there are a ton of cases, particularly in the commercial sector, and there's a lot of contract language out there, particularly in subcontracts, that make it very clear that a failure to give timely notice is a complete waiver of your claim. So immediately when a change happens, that actually I probably should have put that first in the list. Go to recognize what, if any, notice requirements you have and meet them so that this is not an issue you have to deal with later. Call next slide.
Right. And then one thing I was thinking about, Jessica, was, you know, clients will always say, well, that's so much easier said than done. Sometimes we just don't even see it. But a lot of this is training the folks that are in a position to see it and to question and start to question what's in scope and what's outside of scope. A lot of the questions I get are, well, you know, we weren't really sure if it, you know, it's close. We were kind of doing the CO a favor, or, you know, et cetera, but then the favor became bigger and now we're where we are and we didn't have an authorization from the CO really. You know, those kinds of things are really important to identify early. And I know it seems like sometimes we're being nitpicky from a customer relationship standpoint, but if we're not nitpicky and then that little favor became a bigger favor that you need to get paid for, it can be a problem.
And with notices, and this comes up, and this is somewhat outside of this change work, a lot of times there's notice requirements for mechanics liens or bond, state bond requirements, where you have to send these notices to everyone before you even start work, and it causes some agita, if you will, on projects. So there's ways to draft notices using the compliment sandwich, which is, you know, thank you for, you know, opportunity to do X, Y, and Z. We believe this might be or is a change, and pursuant to X, you know, whatever provision, we are hereby, you know, giving you notice of impacts on costs, or, and so you can soften the notice. You just have to make sure that the notice goes out. All right, so delays. This is probably one of the issues that we deal with, I'd say primarily a lot. And again, a delay to a project, there's two ways to think of delays. A lot of times people come to me and say, hey, we were delayed on a project, it cost us a lot of money. Here's a sample of what we think we're entitled to. And I look at it and it's not compliant with FARs, it's not compliant with the contract, and it does not have a basis in the documents that are attached to it. So oftentimes we will then go back to, okay, give us your CPM updates, your baseline, all those documents we talked about to track it. And, you know, one of the biggest issues is time impact analysis. If you're going to allege a delay to your work, you're going to have to do a time impact analysis, at least on most, if not all, federal projects. The other thing I want you to think about is delays don't necessarily mean you're going to get any money, but they might be just as, if not more important, to submit a claim for a delay so that you don't get hit with liquidated damages. So a claim for time is a claim, even though it may not be compensable. If you need to move the contract completion date, you need to do a claim for attendant with the delay. The other thing to think about is, and this goes more to compensation, just because a project finishes on time doesn't mean you weren't delayed. You could have been required to accelerate, for which there would be potentially compensable costs. So those CPM monthly updates, tracking your schedule, doing narratives on a routine basis will help you track delays and the impacts to your work. You know, and most of you probably already know this, you know, when you think of delays, you have to think of them in terms of 4 buckets or 2 buckets with, you know, sub buckets. One, is your delay excusable? Or is it inexcusable? So you want to make a claim to the best of your ability, and you want to track all excusable delays. Now, excusable delays can be contemporaneous with inexcusable delays, and that will still move your period of performance, but it will make it non-compensable. So once you get, so if you do a time impact analysis and you take the project, life of the project, and you come down to the project was delayed 1,000 days, and, you know, 600 of those days were excusable, 400 days of that was inexcusable, then you've got, you take the delta, you've got 200 days of difference, and then you've got to take those out and say which ones are compensable, which ones are non-compensable, because not all excusable delays are compensable, and your contract and the FAR's language is really going to govern that. So it becomes important when the project is delayed, think notice, tracking, scheduling analysis. It is often on very large projects where you have a lot of moving parts and pieces. There are consultants you can get involved very early on to help with scheduling issues if you can't do it in-house. And those scheduling consultants are much cheaper than lawyers. So I find that to spend the money during the project to make sure that your scheduling is done. I have a consultant working on a massive project right now. It's been going on over 10 years. He helps them with their CPM updates. He also helps this particular client with whenever a new schedule is issued, he reviews the P6 files, because a lot of times there's manipulation of the logic, and he can pick those out. And then we can send a notice back to the contractor. We're a significant subcontractor on this project, saying, hey, you changed the logic, you've moved us out of sequence, you shortened certain durations. And I'll give you an example. In one of the recent schedules we got on that project, they added 1,000 days of float to our work, which would make any delays. It essentially forces us to be on that project for 1,000 more days, possibly without compensation. So those are issues that a scheduling consultant can assist you with if you can't do that in-house. And I'm happy, you know, in questions, if you ever need a recommendation for one, I can recommend some. But they're very important. The other issue to consider when you're submitting a delay claim is not to submit, you know, delay costs are very specific, what's included and what's not included. So you have to be very careful. You should track delay costs, acceleration. Most of those, a cost consultant or a scheduling consultant can assist you in how to do that. Doing your own delay, and this is happening more and more, where I see clients submitting their own delay claim and they're running costs that would not be considered compensable, or it makes no sense. They're what we call double dipping. They're billing for things that is part of the baseline work, as opposed to, and one example is this, is if you have acceleration and you're required to be on site more, you know, during overtime, you don't actually get you only get the overage on the overtime. You don't get the base salary or base cost. You only get the half that's added. And if you include the full rate, that could be considered double dipping. There's some only include the fully loaded rate when it's extra work. So those are issues that a cost consultant can help you work through. And I know enough to answer questions, and I can tell when something's done wrong. But these are things to think about in delays. The other issue is subcontractor delays. If your sub-tier is delaying a project so that you don't create delays for which you're going to be responsible uphill, whether it's to a GC or to the owner, you need to review the contract with your subcontractor. You need to mitigate those delays, whether it's requiring the subcontract to accelerate, supplementing or taking other corrective actions, and then back charging the subcontractor appropriately. So because you don't want to create, especially if there's a delay with the owner, you don't want to have your subcontractors create a contemporaneous delay, which could make the delay contemporaneous and non-compensable. So you always need to be tracking your subcontractor performance and mitigating any delays on their part. And I know that was a mouthful. Delay is a big topic. Incomplete, defective specs. If you're a lawyer, Spear and Doctrine, there's a implied promise that the specifications or contractual requirement that you're given are accurate and complete. So a lot of times you'll get on federal projects where the drawings or specifications are incomplete or defective in some regard, and that creates a change. Or you'll have differing site conditions. You get there and they're materially different from what you would expect. Make sure that you're issuing timely notice. So with incomplete, defective specs, that RFIs are going out timely. You can't, and I've seen this where the clients have sat on knowing that there's a defect in the specs or an issue with specs, and then they sit on the RFI trying to internally digest it for weeks, and that's not something that you want. You want to get those RFIs out quickly and then track the response times, because if the owner doesn't respond in a timely fashion, and a lot of times those are set forth in your contract or your specifications, if there's not a reasonable turnaround, you could have delay. So differing site conditions, the same thing. There's some law that basically suggests if you don't track the different site condition, issue notice, and track the costs and the delays caused by it, you're going to undermine any claim you have. So again, this really becomes about notice, tracking, and doing everything timely. Okay, modifications and releases. I tell young associates all the time, I tell some clients too, these are some of the most dangerous documents you'll ever sign. And I see it all the time where a client will say, hey, we have all these unpaid change order requests, or we have delay. And I said, okay, well, give me your pay applications, all of which will have releases through a through date and arguably waive any claim for costs prior to that through date, including changes for work. And it really puts us in a bad position to go back to the well and say, hey, we were doing all this other work at the same time. Yes, it was prior to 3 days, but nowhere in that modification or release or that payment application is that reserved. I've seen it in government change orders and government modifications where there's general release language, and the client wants to go back to the well because there were these additional costs. That becomes really difficult to do legally. Most cases, if it's a commercial job, I tend to have a better chance of making an argument. Federal job, you have to be really careful for asking for something may not be invited. When looking at modification or release language, regardless of what tier your subcontractor, supplier, consult an attorney if you're unsure. The couple minutes, or say it's a half an hour with an attorney, say, hey, can you review this against the backdrop of these facts? Are we waiving anything? It's going to cost you a lot less than the potential claim loss at the end for having waived it. That said, if you're, and this actually, I'm dealing with this right now with a client who has a modification coming down from the government with a complete waiver. And our sureties are really interested in this waiver. And I asked the client, well, did you get waivers from your subcontractors? And there was a little bit of silence. The thing is if you're going to sign off on a mod with the government waiving your right to go back to the well, and the subcontractor has not passed up its claim, not given you a claim, hasn't waived its rights for those same costs associated with that mod, you can have some difficulties. Now, most contracts will have a pay if paid clause, but we'll get into this later. That's not necessarily going to protect you. So best practices is before you sign that mod with the owner, make sure the subcontractors have signed a payment and release or modification first. That's cleanest. It doesn't always happen that way, and I recognize it's not always possible, but it will protect you the most from subcontractors coming back after you've waived your right to go back for more money.
Right. And we understand that sometimes this is frustrating. I had a client that said, but Nicole, like this one change order is holding up a multitude of other change orders that I need to have in hand in order to keep the work moving forward. And the federal government client is refusing to, like they're saying that they won't, modify this release language, but I got to get that one done because then I can't get the other change orders because they want them in order. And, that can be really frustrating. But oftentimes what we find is if I'd rather deal with a dispute over a change and its impact and cost in real time with the CO than like have them waive it and then really get eaten up by it down the road because we didn't have that piece in place. So I understand that it can be very frustrating. And sometimes the question with the client is whether or not you're willing to, eat that cost in order to get everything moving again. And what there are choices to be made, business decisions to be made there. But, we're always going to scrutinize that release language. And if you have questions about how broad release language is, you can always call us. Not all release language is created equal. And so we're happy to help with that if that comes up. All right, so I'll give Jessica a little bit of a break here because I know her voice probably needs a little bit of a break. So I wanted to talk a little bit about prevailing wage liability. And I'm talking not only about the Davis-Bacon Act, but the related acts. You'll see this in the FAR, they renamed all of these prevailing wage rules in FAR Part 22 a few years ago, and it's called Labor Standards for Contracts Involving Construction. Better known to most of us as the Davis-Bacon and related acts. And of course, the Davis-Bacon Act sets prevailing wages and fringe benefits for construction contracts over $2,000. It involves construction, alteration, and repair. Alteration and repair can be really tricky, especially if it's if you have a contract that's like a MATOC or one of these big maintenance contracts where there might be the Service Contract Act and the Davis-Bacon Act in there. We're dealing with a few of these situations right now that it can get really complicated as far as what's the alteration work, what's the repair work, is it Davis-Bacon, is it SCA? So, you should only see it in construction, alteration, repair contracts. And if you pick up one of these maintenance contracts and you think it's squarely SCA and there should not be any DBA in there, you should be looking at that at the bid stage, not later. So once it makes its way in there with the wage determination, you're kind of stuck with it. And I'm gonna talk to you kind of generally about what the issues are, not necessarily to give you a primer on the Davis-Bacon Act because that could take us a couple of days, but really to let you know like what issues we see with the Davis-Bacon Act that can cause companies a lot of consternation and money, highlight some of the changes that the Department of Labor is proposing. We're waiting on final rules, and to give you kind of this is what you should be watching out for. Again, 10, 20,000 foot view of this one. But in addition to the prevailing wage rates under the Davis-Bacon Act itself, you have other regulations, executive orders, ethical responsibilities that you need to be watching out for in the Davis-Bacon Act. And one of them is the Contract Work Hours and Safety Standards Act. This is basically overtime for government contractors that are hiring laborers and mechanics. It's the same rule as FLSA, Fair Labor Standards Act, overtime. Overtime is over 40 hours worked in any 7-day consecutive period. You have to give someone time and a half for that work that is performing, and time and a half is regular rate of pay. So if you had somebody working at multiple rates in multiple classifications, your regular rate is going to be different than maybe the rate that with their straight time rate when the overtime was incurred. What's scary about the Contract Work Hours and Safety Standards Act is that if you don't, or if you fail to pay the overtime or fail to pay it at the correct rate, you can be subject to a penalty, and that penalty changes basically every year or two, and it's a daily penalty that's applied for every worker that does not receive the correct overtime. And that, so every day that they worked overtime and didn't get paid, you're going to be subject to these liquidated damages. If it's under $500, you can negotiate with the contracting officer directly, but Department of Labor is the agency that's going to necessarily assess it. And that can add up really quickly. I mean, overtime's expensive to begin with. And usually it's not an issue of recorded time, it's an issue of unrecorded time. My foreman on the job site said, or my supervisor said I wasn't supposed to record the time. It can't be charged to the government for a fixed price contract, whatever the case may be. And so I didn't record it. And we are, facing down not exactly just records, but allegations that employees are making and trying to negotiate with the Department of Labor based on, what we know to be true and what our information is. And so this overtime liability can get very expensive very quickly. We also have the Copeland Anti-Kickback Act, which is the act that actually requires those certified payrolls that you guys have to submit on a weekly basis if you're actually having employees do this work covered by the Davis-Bacon Act. And a lot of more sophisticated or companies with a lot of experience, they know how to do the certified payrolls and do them correctly. But if you've picked up a certified payroll for the first time, it's not always obvious, how to fill it out. And there is guidance online, but you should be cognizant of subcontractors that are perhaps not used to federal work filling these out, or assuming that someone's a sole proprietor, independent contractor, so they don't have to put them on the list, or you classified someone incorrectly, which I'll mention here in a little bit as well, and so you put the wrong wage rate on that certified payroll. Every time you submit those certified payrolls to the federal government, or you pass them through from a sub to the government, that is a claim you are making to the government that you've complied with the act. And if you fail to do that correctly, you can be subject to False Claims Act liability and a parade of horribles that is very unpleasant. I mean, I had a case several years ago now where it was a small HVAC contractor whose it was a family-run business. Spouse was handling the certified payrolls and had a penny rounding error. And they had some other issues with the Department of Labor, but that rounding error put them in False Claims Act liability space. So, you just want to be as accurate as you can. We resolved that, but it's like, it was a rounding error. The payroll didn't match the certified payroll. The Copeland Anti-Kickback Act makes it impermissible to induce employees to give back compensation. So a lot of times what I see in this area is, subcontractors that might have employees that are working on federal projects and non-federal projects, and they pay the federal rate that tends to be maybe higher than the commercial rate, although I think labor shortages in recent years perhaps has challenged that historical trend that Davis-Bacon is higher than commercial work. But there have been a number of cases where the employer says, okay, we'll pay you the Davis-Bacon prevailing wage for this job, but on that job over there, I'm going to pay you essentially under market, and your pay will average. That is an example. Or we go to the ATM. That's an example of kickbacks. You have to be very careful about any insinuation that you're essentially clawing back those prevailing wages in a different way. And of course, that has criminal and civil liability attached to it. There are also minimum wages for government contractors. This comes up for me more in service contracts than construction contracts, but it is a minimum. It's currently $16.20 an hour as of January 1st. It can go up every year. This FAR clause, which is 52222-55, should be in your contracts, and it will go up every year on January 1st. So even if you think no one you have working for you is affected by this right now, it could be affected. They could be affected in 2024, 2025. It also applies to in connection with workers. So they don't have to be working just on the federal project under DVA. They could be working in your office, for example, but working 20% or more of their time on a covered contract, and could affect them. And of course, since 2017, we've had sick leave for federal contractors, which attaches to Davis-Bacon contracts as well. And that requires that, that workers get 1 hour for every 30 hours worked on these covered contracts. That can be challenging to administer in a world where you have commercial and federal contractors, and perhaps your workforce is not accustomed to getting sick leave. Maybe they're getting a cash out. They're used to getting everything in cash, and they just don't work when they don't work. Just keep that in mind. Okay, let's go. I see a question. It's an ACA question, so thank you for submitting it. I'm going to try to come back to it. I just wanted to acknowledge that I did receive your question about the Affordable Care Act definition of a temporary employee, and I'm not ignoring it, but it has a little bit of it can be a lengthy answer, so I'm going to come back to it a little bit later, or I'll get back to you on that one. Okay, let's talk a little bit about what's coming down the pike, because there are a number of proposals that DOL put on the table. It's to revamp the Davis-Bacon Act, and it's one of the most significant changes in the Davis-Bacon Act really to date. It hasn't been changed this significantly in a long time. And the proposed rules really laid out some things that I think the Department of Labor is trying to test and would like to see, and might impact service contracts down the road as well. A lot of it is very controversial, and that is why, and the number of comments is significant to this, to the proposed rules. We are waiting to see. I think, the sense I'm getting from folks here is that the final rules likely will not be issued until a new secretary is at the Department of Labor, which was also heating up recently. We might have a new secretary there soon, and just to make sure that once it rolls out, it's rolled out kind of with the blessing of the secretary. So what do I mean by return to the 30% rule? There was kind of during I believe the Reagan administration, they kind of scrapped this 30% rule. But the long and short of it is that there used to be a way, when you didn't get enough responses to the surveys that the Department of Labor sends out to determine the prevailing wage rules, it was a way for them to determine what the wage should be in the locality. And it tended to favor higher, or at least the perception was that it favored higher prevailing wage rates. And so they really abandoned it a while back. And there is this sense that the Department of Labor, via regulation, would like to return to that so that they can more easily set prevailing wage rates when you don't get responses to the surveys. And I certainly understand the challenge that the Department of Labor has when organizations, when they feel like they don't have enough information to set forth a rate in a locality. On the other hand, the concern is that it artificially inflates you know, federal work above commercial work, which can create some challenges because it's supposed to be prevailing wage rate in the locality. The same sort of goes to this idea of rural and urban wage surveys. So they used to, or currently, are separating. You might have a locality, at least for the general wage determinations. You might have a locality, but they separated out the rural areas from the urban areas for purposes of the wage surveys. And DOL has proposed aggregating those again. You know, my sense is that some of this could be just due to, you know, people from different areas are kind of, you know, coming into the city for some work, maybe staying outside of the city for other work, and does it make sense that they, you know, would get significantly different rates based on where they're working as opposed to where they live, and maybe we should aggregate those. But I do tend to agree that the end result will be an increased wage rate across a larger locality. And again, these are very high level, not really digging into the final rules terribly, but just to give you a sense that these wage determinations are set to change significantly if DOL blesses, you know, these final rules. They're expanding coverage to material supplier drivers, which is new, right? So the Davis-Bacon Act applies on site, it doesn't apply off site. And so sometimes when you have material supplier drivers coming off site to on site, there has been discussion about whether the Davis-Bacon Act should apply to them. They would like to expressly include material supplier drivers as covered by the Davis-Bacon Act, which, you know, means that if you had, say, supplier drivers that were, you know, not incidental to your necessarily to your work, but that you hired out, it could create interesting issues about flowing those requirements down to companies that would handle your supply delivery. Because there's always this issue of, you know, driver brings pallets of X, Y, and Z into the site, then offloads them. Which work is subject to the Davis-Bacon Act and which is not? The driving on site is not, but then you have to worry about their offloading pallets. So could that be? So, you know, they're trying to expand the coverage of the Davis-Bacon Act in that regard. One of the most significant changes, I think, and this is, I think, long been on the wish list of the Department of Labor, is this applicability without a wage determination, that they would put it on the onus on the contractor to find a wage determination. Right now, it's, you know, really driven by which wage determination is in your contract. You don't have to go out and find one. There's also an easier debarment standard. They want to put it in line with the Copeland Anti-Kickback Act. You know, DOL is already being very aggressive about violations and proposed debarment, particularly if you don't kind of acquiesce to their position. And so, you know, I would be hesitant to encourage them to do that, even if it doesn't align the standards. I don't think it's necessary. They add an anti-retaliation provision, which would be very new, where, you know, if somebody complains about certain violations of the act, you can't retaliate against them. And of course, they're doing things like adding conformance processes where there's no survey data to support a new position. I don't necessarily think that's a bad thing, but I do think it shifts the risk much more onto the contractor, which is not necessarily a good thing, and creates issues in bidding. Who's going out to get a conformance? What it tends to do is just drive everybody to put people in classifications that they really shouldn't be in, which then creates a compliance problem. And they're adding all sorts of things that they've kind of done ad hoc into the regulation. So the annualization when it comes to benefits, multiple wage determinations and how to handle those, apprenticeship regulations that used to not be in the regulations, they're sort of adding in. So we're going to see big changes to the Davis-Bacon Act this year. The greatest areas of risk I see, just very quickly, and I know we need to move on, is classification under wage determinations. You know, independent contractors, sole proprietors versus employees, getting a lot of attention. Be very careful. Your contractor is not checking for union area practices. So just because it's not in your wage determination, you have to comply with whatever union practice is in the locality. So for example, if the carpenter union pays 8 hours a day, if even 1 hour of carpentry work is performed, you're supposed to comply with that area practice. And that can cost a lot of money if it's missed, and it's not always obvious on its face. You know, False Claims Act due to certified payrolls. I talked about intersection of the Service Contract Act, and OFCCP liability, which is basically the EEOC for federal construction contractors. They're starting to examine construction contractors more than they have in the past. And there's a different standard of rules that kind of impact construction contractors. So if you haven't heard OCCP, it's not in your subcontracts or you're not flowing it down, make sure that you're paying a little bit more attention there as well. And finally, there's this reach into the IRS to encourage prevailing wage liability and prevailing wage compliance, the Inflation Reduction Act and Clean Energy Tax. There's clean energy tax benefits that apply to commercial businesses that want these tax credits and federal construction contractors. I just included the list here. It's a litany of different clean energy tax benefits, but in order to get the credit or the tax benefit, you have to agree to comply with the Davis-Bacon Act. So the IRS is getting into the Davis-Bacon Act world with this, and also general compliance. Fun stuff. So Jessica?
That's a lot of information. So I'm sure there'll be a lot of questions. Slipping from labor, we'll go into bond claims. I know that all contractors that contract with the government in excess of 150 grand have to provide a performance bond and a payment bond. But good practice for any contractor is the requirement that your significant trades also provide a performance bond and a payment bond. Those performance bond or payment bonds by your subcontractors are not governed by the Miller Act. They are governed by general contract law and common law in the state, for usually that's referenced either in the bond or in the contract where the project is performed. Focusing on the Miller Act, performance bond particularly, these, the surety has the obligations. If the performance bond, the government makes a claim against the performance bond, it arises if basically the contractor breaches the terms of the contract with the government, fails to comply with all of the covenants, terms, conditions, agreements, including modifications during the original term or any extensions, and this is important for the life of any guarantee. So one of the questions I often will get is, we want to turn, we're selling our business, we're getting out, can we just cancel our performance bond? That's not something you can do. You don't terminate these bonds. They're out there until you have fully complied with the requirements under your underlying contract. The surety has certain options once a claim is made, and they're listed here. They can take over and complete. They usually are not in the business of doing their own construction, so they usually hire a replacement contractor. They can also, and this happens from time to time, where the bond principal, the contractor, if you will, is running out of money on a project and will be in default, but for the surety financing the principal's completion of the work. And that happens from time to time. The surety also, and this is less known, but it's case law support, they can also tell the government, we're not going to complete the work. You complete the work and we'll indemnify you up to the bond amount for whatever costs are. They can also pay out the bond application or obligation, and then obviously they can deny the claim. Performance bond issues get very complicated. We could do days and days of presentation on all the nuances of performance bond issues. Once a performance bond has been hit, that's what I call it, it gets very complicated for the contractor because ultimately the contractor is going to be liable to the surety for the costs, but yet will no longer have any control over how this project is completed. So it becomes difficult for the contractor to track costs and liabilities going forward. And then the surety is charged with getting the job done. And sureties are not contractors, so they often hire something like a construction manager to assist in the completion. But it tends to be a very painful process for all involved. And so just keep in mind that when the government does call your performance bond, you want to avoid that at all, to the extent you can. It just is such an unpleasant experience. And trust me, that I've got 2 going on right now where we're just managing and mitigating the issues. So that's performance bonds generally, and what the issues are. Next slide, Nicole. There's one other thing that with the performance bond defenses, these are some issues that lawyers will typically think about if there's a claim against the performance bond, and you're representing the surety. Is some of these plans, you have the defenses of the contractor: defective plans, delays, impossibility of performance, wrongful termination, failure to provide notice and an opportunity to cure is one, and then any set off. So the surety, hopefully, and usually in the takeover agreement, will also adopt all the claims that you would press against the government prior to termination, delay claims, to mitigate some of the losses. Other defenses could be a material alteration of contract. That's a tough one. It really has to be material, kind of a cardinal change to the contract to undermine the surety's obligation. The other issue is overpayment by the government to the contractor for work that wasn't completed. Termination for convenience. For the contractor, that's great. And for the sureties, that's great because it releases liability. And then the release of the principal. If the government releases principal, we can use that defense. And the other defense is the government's failure to mitigate damages. So those are just some general concepts that you might see the surety raise if a performance bond is hit with a claim. The bigger issue I find for my clients are payment bonds. And keep in mind, I'm talking about federal projects. There are payment bond laws. There's the Miller Act, but there's little Miller Acts in all of the states. So and each one of those states' laws has different requirements. And just like the Miller Act, if you don't meet the requirements, you lose your rights. So, if you've got a state project and you want to know what the state's laws, most of this stuff you can literally Google it and find it online. And there's a lot of good websites that'll give you some basic information on the various states' laws. But under the federal law, the Federal Miller Act, it protects subcontractors and second-tier subcontractors. It does not protect third-tier subcontractors. So if you're a subcontractor, to mitigate your risk on a project, you should know where you are in line. And sometimes that's complicated. And I've seen this on federal jobs where you have a joint venture at the top with the government, and then the joint venture contracts with a related entity of one of the parties to the joint venture, and then they start subbing it down. And so while you think you're in contract with the first tier, you're really not. And you don't have bond rights. So if you're a subcontractor, one of my biggest pieces of advice when you contract with for a large project is know where you are in line to see if you're going to have bond protections. The second issue is if you are a subcontractor not in contract with the prime contract or the principal on the bond, you have to provide 90 days notice from completion of your failure to get paid, and warranty work does not extend that time. So I have fought for contractors that exact issue on a federal job where warranty work was used as a basis for extending that 90 days, and they lost. So the other issue is timely suit. The claim needs to be brought within 1 year. And then what's covered: labor, material, service, equipment changes. That can include costs, direct costs associated with delay. Mandatory pass-through claim requirements does not toll the deadlines. So if you're a subcontractor and your contract says you're going to pass through your claims that will be given to the government, and you're not going to bring any claims, and your rights are limited to whatever the contractor recovers from the government, that doesn't kill your deadline. But more important, pay if paid clauses are not a defense to a payment bond, not under federal law. So I think I've gotten 3 of these in the past 2 months where a contractor has received a bond claim notice, sent them to me and said, well, we weren't paid by the government. The government denied this claim. So we have a complete defense. And I have to be put in that unfortunate position where I tell them that's not a defense to the surety's obligation. And so that often will surprise people, but also keep in mind, the laws are changing anyway in many of the states. That pay if paid clauses are, the pendulum swinging the other way, are becoming an issue for many states, and they are legislating laws that make them unenforceable. And so just be mindful of that anyway. But when you're looking at a bond claim, a pay if paid clause is not going to protect you necessarily. You do have other contractual defenses to avoid liability, set-offs, failure to perform work, delays, breaches, all of those issues. But your strongest defense, and this is, I circle back to that, is that you have a payment application with the waiver and release language signed by the claimant. And that is one of the things when I get a bond claim from a contractor client, I'll say, well, give me all their payment applications. Let's see what the last through date was and how that language read. Take a look at your partial and your final waivers, and you may want to revisit the language in them. Make sure that they're strong in terms of the waiver language. Make sure that they waive everything, known and unknown, for all work up through the through date, so that you can then use those waivers to fight against any payment bond claims for work that happened prior to that date. The other issue is know your indemnity agreement with your surety if you're a contractor. I recently had a contractor come to me who is unfortunately failing and is really kind of the end of its financial rope because of 2 projects that went upside down and a host of other issues. And they thought, well, we'll just bankrupt the company. I said, well, go get your performance bond indemnity agreements. Let's see who signed those. And all of a sudden they're finishing the job because there were like 6 people who signed, 6 of those corporate folks that signed it along with their wives. And they all live in very nice homes, and the surety will go after everything. So if you bankrupt the company, the surety will pay, and then they're going to come after everybody who signed that indemnity agreement. Those indemnity agreements are very broad. And they will bill you for every staple they use in addressing a claim. So before you decide to fold a company in hopes, and sometimes that happens, go make sure you look at what you've guaranteed or indemnified as a principal. So that is very important. Okay, subcontractor and supplier liability. And I know we're running out of time. I'll do this quickly. Subcontractor drafting, don't just give one form subcontract to all your subcontractors. Some of the biggest issues I see are, and this is for subcontractors too, the scope of the work is not adequately defined, exclusions are not adequately listed, causing confusion. The schedule of the work for that subcontractor is not adequately defined. And that's okay. Sometimes it could be the project schedule and you could put language in there, but if you're a subcontractor and you're agreeing to a schedule you haven't seen yet, you may be signing a contract and be already behind schedule. And I have absolutely seen that. Well, I didn't know, I didn't see the schedule. That's not going to be excuse. Make sure you get the schedule, know what you're agreeing to, and that you can perform it. Clear pricing. This is a big issue I see, where just happened today, where the client didn't clearly price certain work and part of it got de-scoped, and now there's a huge fight over it. If you can be clear on pricing, especially if it's a supply type thing and unit prices, make sure that's clear. And when I say clear, it's clear in the industry. If it's only clear to one party, it's going to be, subject to some disputes. Adequate flow downs on a federal project. Make sure you incorporate the prime contract requirements as it relates to the subcontractor's work, the specs, the drawings, and all applicable laws. There are mandatory clauses that must flow down in your subcontracts, and I listed some of them. Those are going to be listed in your contract with the government. So you just copy, cut, and paste it, but just make sure that you flow those down. And then order of precedence clauses are extremely important. And that is, hey, we're going to incorporate the prime, and then we have a subcontract. Well, if there's a conflict between the prime contract and the subcontract, what's going to govern? Don't just pick the subcontract or the prime contract, because that doesn't necessarily make sense with respect to all clauses. So you should really consider, if you want a venue clause that's better for you, but you want the rest, and it's in the subcontract, but the prime contract has better other provisions, you can parse that out very easily. And otherwise, if you don't think it through, I actually fought a city in Maryland over this. They didn't think through their order of precedence, and I was able to avoid a notice obligation regarding scheduling that would have killed my client's claim. But they didn't, and so it was a mistake on the city side that helped us. But just remember, order of precedence clauses are extremely important, and they ought to be thought through. So next page. Make sure you have a termination for convenience clause, and think about what you want to pay and not pay them for termination for convenience. If you can get a subcontractor not to agree not to get paid lost profit on the terminated work, that's probably ideal if you're a contractor, not so ideal if you're a subcontractor. Changes clause, make sure you have a notice provision if you're a contractor. If you're a subcontractor, make sure you meet that notice provision, because if there isn't a notice provision, you don't want to be stuck in a position where you didn't know it existed and you've resolved your claim with the government. Time periods for claims, and if you don't hit them, make sure that they're waived if you're a GC. I always include pay language. I know I speak out of both sides of my mouth. If you're a subcontractor, you want to mitigate that language to suggest that if the check is not paid for your work, it has nothing to do with you or any default, that you should be paid within a certain period of time. So you can soften that language, and I often do. And make sure you include pass-through requirements for claims arising from the government, so that the subcontractor's claims get passed through to the government to deal with. Suspension of work, make sure that you have language that's passed through into your subcontracts, because if the government suspends work, as it often does, you want to make sure that the rights are mirrored, contractors' rights and the subcontractors' rights with respect to government suspensions. Indemnification, you want to make sure your indemnification language is broad with your sub tiers, including false claims acts. If your sub passes up a false claim, you don't want to be liable for it. Claims for personal injury, property damage, defect, and breach. So there's first party indemnification and third party indemnification. Indemnification, unless you specifically allege that they're to indemnify you from loss and damages for their breach of your contract, it's only going to cover third-party claims, not necessarily the contractor's own costs associated with breach. Defective work, delay work, violation of laws, bond claims, environmental claims, workers' comp laws. The workers' comp issue, this is important. Make sure your workers' comp indemnification includes a workers' comp immunity waiver. That in Maryland, you don't need any magic language for that, but in Pennsylvania you do. So know what state's laws applies. Talk to the Nicoles of the world to find out whether the workers' comp law reference and an indemnification needs to have magic language. I can also help in that. Okay, next. Make sure you have a default disputes clause. I adequately define the default. Notice an opportunity to cure. Keep that cure period short if you're a contractor, and then make sure you have certain rights upon default, taking over equipment, supplies, materials. The other issue is your venue and applicable law consideration. Know the relevant state's laws before applying it. Don't just pick the state you're in. It may not be the best state's laws for construction. For example, Virginia is not great if you're a contractor, because contracts after January 1st can no longer have pay if paid. But if you're a subcontractor, it might be a great state for you. So just know, don't just blindly pick a state. properly vet your subs, financial solvency, go on websites, see if they've been sued. Find out if you're insecure, find out if they can obtain payment and performance bonds that will protect the contractor and the job. And then see if they have experience on federal projects, because there's a lot of laws and regulations, including all those labor laws, that they're going to have to comply with. And that just, it's going to make a contractor job difficult if your subcontractor isn't experienced. Okay, this topic in the next bullet point, this is just for mentioning, subcontracting plan requirements under the SBA. Do you need it? What does it look like? These are issues that you should be aware of. If you're not, reach out to an attorney. I referenced the FAR clauses. You can take a look. There's some information online about these, and the government puts out some. The SBA has some interesting articles on it and cheat sheets, so you can definitely check it out. And then subcontractor payment. This is another big thing. Make sure you're obtaining waivers and releases of all claims as of the through date, and that you're getting indemnification from sub-tier claims. I know I said that really fast.
Woo! So yes, we're over time, and never give lawyers the mic, right? But I think we did it in, we're under 10 minutes over. So I'm going to say that's a success. And I appreciate those of you that could stay on. And there's a lot here, but I think it hopefully will raise awareness for issue spotting purposes. And hopefully you got some good tidbits out of the webinar today. Thank you so much for joining Jessica and I. I will get back to everybody if they on any questions you submitted, and if you didn't get a chance to submit a question, please do so. And again, we're so glad we have Jessica on our team. She had the wealth of information and a compliment to Player Methods practice. I hope everyone has an excellent afternoon.
Thank you, everyone.